Buhay! This is Mr. CrimiKNOWlogy at welcome sa ating mga pag-aaral tungkol sa subject matter ng criminology at disciplines nito. Ito ay para sa research ng mga criminology students, para sa review ng mga future criminologists at mga refresher ng mga registered criminologists. Ang ating pag-aaralan para sa araw na ito is entitled
Search and Seizure under the revised rules on criminal procedure. So now, let's begin our lesson by defining what is a search warrant. A search warrant is defined as an order in writing issued in the name of the people of the Philippines, signed by a judge, and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. So, ang search warrant ay isang order in writing na nakapangalan sa people of the Philippines na signed ng judge to direct or para utusan ang isang peace officer or let's say a police officer to command that officer para i-search ang mga personal property na naka-mentioned or naka-stated doon sa search warrant. At once na na-seize niya yung mga stated properties, ay kinakailangan niyang dalhin ito sa korte. Court where application for search warrant shall be filed. An application for search warrant shall be filed within the following. A. Any court within whose territorial jurisdiction a crime was committed. So, if a-file mo yung search warrant doon sa korte kung nasaan merong territorial jurisdiction kung saan na-commit ang isang krimen. Doon ka rin, the same territory ka rin dapat mag-file ng search warrant doon sa korte kung nasaan naganap ang krimen. Letter B, for compelling reasons stated in the application, any court within the judicial region where the crime was committed, if the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. So, kapag ka meron kang mga dahilan, compelling reasons sa pag-a-apply mo ng search warrant, kahit saang korte na nakapaloob sa judicial region kung saan na-commit ang crime. Lalo na kung alam mo kung saan na-commit ang crime, kahit saang korte na nakapaloob sa judicial region na yon, kung saan din yung warrant ay i-enforce or ipatutupad. Pwede ka rin mag-apply doon. However, if the criminal action has already been filed, the application shall only be made in the court where the criminal action is pending. Kapag ka daw meron ng criminal action, it means meron ng preliminary investigation na nakandak kung saan si prosecutor ay didetermine niya meron bang probable cause. Or, pangalawang grounds dyan, kapag ka na-file na yung criminal charge sa municipal trial court o kung saan naka-file o saan ginawa yung criminal action, doon ka rin dapat mag-apply ng search warrant. Personal property to be seized. Search warrant may be issued for the search and seizure of personal property. A. Subject of the offense. B. Stolen or embezzled and other proceeds or fruits of the offense. Or C. Used or intended to be used as means of filing or committing an offense. So, ano ba yung pwede mong i-seize na personal properties? Naka-state dito na letter A dapat subject ng offense. Kapag ka hindi subject ng offense, hindi mo yun pwedeng i-seize. Pangalawa, ito ba yung ninakaw or illegally gained mo or proceed o bunga ba ito ng offense na na-commit? Pwede rin niyang i-seize. Or ito ba yung mga property o mga bagay na gagamitin o balak gamitin bilang pamamaraan upang makomit ang isang offense? Pwede rin niyang maging subject ng search and seizure. Requisites for issuing search warrant. A search warrant shall not issue except upon probable cause in connection with one specific offense to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describe the place to be searched and the things to be seized, which may be anywhere in the Philippines. May mga requisites or mga requirements para makapag-issue ng search warrant. Siyempre, hindi ito pwedeng ma-issue maliban merong probable cause na ma-determine ang judge. Ibig sabihin, merong sapat na ebidensya para sabihin na meron talaga na-commit na offense at probably yung mga hinahanap ay yun nga may kinalaman nga doon sa offense committed. Siyempre dapat one specific offense lang. And personally by the judge na matapos niyang in-examine under oath yung complainant at mga witnesses na pwede niyang ma-produce ay particularly describe yung lugar na sa search at mga bagay na dapat i-seize anywhere in the Philippines, saka lang siya pwede mag-issue ng search warrant. Examination of complainant record. The judge must, before issuing the search warrant, personally examine in the form of searching questions and answers in writing and under oath the complainant and the eyewitnesses he may produce on facts personally known to them and attach to the record their sworn statements together with the affidavits submitted. Now, yung pag-examine ng complainant ni judge at yung record na mapaproduce out of this, kinakailangan bago mag-issue ng search warrant si judge, dapat personal niya muna in-examine in a form of searching questions and answers na dapat in writing ito and under oath. Dapat niya munang tanungin, usisain ang mga complainant at yung mga witnesses na pwede niya i-produce na meron talaga silang personal knowledge of facts na regarding dito sa crime committed at i-attach niya itong sworn statement nila kasama ng mga affidavit na sinubmit. Issuance and form of search warrants. If the judge is satisfied of the existence of facts upon which the application is based on that there is probable cause to believe that they exist, he shall issue the warrant, which must be substantially in the form prescribed by these rules. So, para ma-issue ng judge yung search warrant, kinakailangan mo na satisfied si judge na upon the existence of the facts na kanyang inusisa ay talagang meron nag-exist na probable cause para paniwalaan talaga. At kapag ka meron talaga, he can issue that search warrant na dapat yung form and substance o laman nito ay na-meet niya yung mga requirements na nabanggit kanina. Right to break door or window to effect search. The officer, if refuse admittance to the place of directed search after giving notice of his purpose and authority, may break open any outer or inner door or window of a house or any part of the house or anything therein to execute the warrant or liberate himself or any person lawfully aiding him when unlawfully detained therein. Ang peace officer na nagsaserve ng search warrant ay may karapatang mag-break in and break out o sumira ng mga pintuan o ng mga bintana para lang ma-effect niya yung search. Matapos niyang ipakilala ang kanyang sarili, ang kanyang authority, at yung purpose niya in serving the warrant, tapos nirefuse pa rin ang kanyang pagpasok doon, sa kanya pwedeng execute yung kanyang pag-break in at pag-break out. Or once na ang peace officer ay kinulong unlawfully sa loob ng kanyang pinasokang property na kung saan siya nag-search, may karapatan din siyang mag-break out or any person na tutulong sa kanya para makalabas ay may karapatan din na mag-break out doon sa property na yon. Search of house, room, or premise to be made in presence of two witnesses. No search of a house, room, or any other premise shall be made except in the presence of the lawful occupant thereof, or any member of his family, or in the absence of the latter, two witnesses is sufficient age and the discretion residing in the same locality. Now, bago mo i-search ang isang bahay, isang silid, o isang pagmamay-ari dapat meron munang present na dalawang testigo or mga witnesses. Hindi ka pwedeng mag-search ng walang mga witnesses. Dapat present una yung lawful occupant, yung talaga nakatira doon, o yung may-ari ng property. Or kung wala man sila, dapat meron dalawang member ng same locality na sufficient age, ibig sabihin 18 and above, at merong tamang discretion para maging witness mo upon searching the house, the room, or the premise. Time of making search, the warrant must direct that it be served in the daytime unless the affidavit asserts that the property is on the person or in the place ordered to be searched, in which case a direction may be inserted that it be served at any time of the day or night. Ideally, and as a general rule, dapat ang search warrant ay iserve during daytime. But, pag merong affidavit na nag-a-assert or nagpapatunay or nagsasabi na ang property ay nasa taong yon or nasa lugar na yon kung saan i-order na i-execute ang search warrant, pwedeng i-insert doon, i-direct doon sa search warrant na pwede itong iserve at any time of the day or night. Validity of search warrant. A search warrant shall be valid for 10 days from its date. Thereafter, it shall be void. Ang search warrant ay merong expiration date. Dapat, upon issuance nito, within 10 days dapat ma-serve. Kapag kahit hindi ito na-serve, it will be void. Wala na itong halaga or di na ito valid. Receipt from the property seized. The officer seizing property under the warrant must give a detailed receipt for the same to the lawful occupant of the premises in whose presence the search and seizure were made, or in the absence of such occupant, must in the presence of at least 2 witnesses of sufficient age and discretion residing in the same locality, leave a receipt in the place in which he found the seized property. So, pagka nag-search and seizure na ang peace officer, kinakailangan siyang mag-iwan ng resibo. O sa resibong yun, nakalagay yung detailed na mga sinis ng mga properties. Dapat iwanan ito sa lawful occupant, yung talaga may-ari ng bahay, na may-ari ng premise na yon o ng room or ng house na yon, or kung wala man yung may-ari doon sa dalawang witnesses na residing in the same locality na merong sapat na edad at merong sapat na discretion, dapat iwanan yung receipt na ito doon sa lugar kung saan na-found at na-seize yung property. Delivery of property and inventory thereof to court, return and proceedings thereon. A. The officer must forthwith deliver the property seized to the judge who issued the warrant together with true inventory thereof duly verified under oath. Matapos ma-seize ng peace officer yung mga property naka-direct doon sa search warrant, kinakailangan niyang dalhin yung mga property yon doon sa judge na nag-issue ng search warrant. B. 10 days after issuance of the search warrant, the issuing judge shall ascertain if the return has been made, and if none, shall summon the person to whom the search warrant was issued and require him to explain why no return was made. If the return has been made, the judge shall ascertain whether Section 11 of this rule has been complained with and shall require that the property seized be delivered to him. The judge shall see to it that subsection A thereon has been complied with. Matapos ang 10 araw, dapat siguraduhin ni judge na naibalik yung search warrant kasi meron na itong validity for 10 days. Now, kapag hindi ito nabalik, kinakailangan ng isumon yung tao kung kanino na issue, na direct yung search warrant at pagpapaliwanagin siya bakit hindi na sa uli yung search warrant. Now, kapag nabalik naman yung search warrant within 10 days, ang judge naman kinakailangan niya siguraduhin na natupad yung Section 11. Ibig sabihin nun, natupad yung pagbibigay ng receipt sa lahat ng properties na sinis ni peace officer. Kinakailangan yung mga na-seize na property din, siguraduhin din ni judge na may deliver sa kanya ang lahat ng mga bagay na yon. Letter C. The return on the search warrant shall be filed and kept by the custodian of the logbook on search warrants, who shall enter therein the date of the return, the result, and the other actions of the judge. Matapos may balik yung search warrant na sinerve nung peace officer, kinakailangan ng custodian naman ay i-file niya ito at itago sa isang logbook ng mga search warrants. At kinakailangan ilagay niya yung petsa ng pagbabalik, anong resulta, at ano ba yung mga actions na ginawa ni judge in detailed form. A violation of this section shall constitute contempt of court. So, ibig sabihin, kapag ka na-violate yung mga binanggit kanina na tatlong mga bagay, pwede itong mag-result into contempt of court or pamabasto sa korte, which is another problem. Search incident to lawful arrest. A person lawfully arrested may be searched for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense without a search warrant. Now, pag ang isang tao ay lawfully na inaresto, ay pwede rin siyang i-search, baka meron siyang mga dangerous weapons or mga illegal things na under his possession. Pwede rin itong, pagka ito ay sinearch siya, na pwede itong magamit na pruweba na meron ba talagang krimen na na-commit kahit na wala pang search warrant. And lastly, motion to quash a search warrant or to suppress evidence. Where to file? A motion to quash a search warrant or to suppress evidence obtained thereby may be filed in and acted upon only by the court where the action has been instituted. If no criminal action has been instituted, the motion may be filed in and reserved by the court that issued the search warrant. However, if such court failed to reserve the motion and a criminal case is subsequent filed in another court, the motion shall be resolved by the latter court. So generally, ang section na ito ay tungkol sa pag-apply ng defense na i-void or i-reject na yung search warrant or para masuppress din niya yung mga ebidensya na na-obtain mula sa search and seizure na naganap. Pwede lang i-file ang search or ang motion to quash na ito doon sa judge or sa court kung saan na-institute yung criminal actions. Yun ang let's have a separate topic about the motion to quash. But generally, these are the rules, procedures tungkol sa search and seizures.
Hope kahit paano ay naging beneficial ang lesson for today, and I hope and pray na maghanda ito sa mga nagre-research, mga nagre-review at mga nagre-refresh. If you find this video beneficial, you can like, you can subscribe, you can comment down below, you can share this para maraming makinabang. At kung meron kayong katanungan about sa subject na ito, please comment down below so that we can discuss. If you have requested topic also, please comment down below para we can consider discussing that. Again, thank you very much and God bless you all.